I'm going to talk about corporate law, what it actually is, and why every business eventually needs it. I'll discuss an overview of corporate law, what it is, why it matters, and the legal mistakes that can quietly destroy a business before it ever becomes successful. A lot of people hear corporate law and imagine public companies, billion-dollar mergers, or executives and skyscrapers. That was my initial training. But the reality is that corporate law affects almost every business, from a two-person startup working in a garage to a family business with 5 employees. At its core, corporate law is the body of law that governs how businesses are formed, operated, financed, and eventually sold or dissolved. And the interesting thing is this: most business problems are not caused by bad ideas. They're caused by unclear ownership, poor documentation, bad contracts, and misaligned expectations. That's where corporate law comes in. Part 1. What corporate law actually covers. Corporate law is broader than people think. It includes choosing the right business structure, forming companies, drafting operating agreements and bylaws, issuing ownership interests, protecting founders, investor relationships, employment and contractor agreements, vendor agreements, commercial contracts, corporate governance, compliance, mergers and acquisitions, dissolutions and exits. In simple terms, corporate law creates the legal framework for how a business functions. Without that framework, businesses operate on assumptions, and assumptions become lawsuits. Part 2, the major decision, entity formation. One of the earliest legal decisions a business makes is choosing its entity structure. Usually that means deciding between an LLC, a partnership, or a corporation. The entity choice affects taxes, liability, fundraising, governance, and ownership rights. For example, many startups initially form LLCs because they're flexible and simple, but venture capital investors often prefer Delaware C Corps because they fit the structures that investors are used to. The legal structure should align with the business goals. The issue is that many founders rush through formation without thinking long term. They split ownership equally because it feels fair. Then 6 months later, somebody stops working, somebody else claims they own the same amount, somebody else is doing all of the work. It just becomes a legal and business disaster. Part 3, founder problems are one of the biggest risks. One of the biggest sources of court disputes are founder conflict, not competitors, not regulators, but the founders. Why? Because many businesses start informally between friends or family. They trust each other and they avoid uncomfortable conversation. They don't discuss equity vesting, decision-making authority, exit rights, compensation, or what happens if someone leaves. Then the business starts making money, and that's when legal problems occur. A strong operating agreement or shareholder agreement forces those conversations early. For example, who can bind the company to contracts? What happens if a founder quits? Can ownership be sold freely? How are disputes resolved? Who controls company decisions? Good corporate law planning is often about preventing future emotional disputes. And that's something to keep in mind. So, part 4, limited liability. One major reasons businesses form entities is limited liability. People hear it constantly, but they don't fully understand that term. It generally means that the owners are legally protected and separated from the company's obligations. So if the business is sued or owed money, the owner's personal assets may be protected. But here's the very important part. That protection is not automatic. The courts can sometimes pierce the corporate veil. That means they ignored the liability shield because the business wasn't operated properly. This can happen if the business commingled funds, records are ignored, fraud occurs, or the company is treated like an alter ego rather than a real entity. So forming an LLC is not enough. You actually have to operate like a business. That means separate bank accounts, contracts in the company's name, proper documentation, and corporate formalities. A lot of small businesses skip this step because it feels unnecessary until litigation happens. Then it's a problem. Contracts run businesses. Businesses operate through agreements. Every important relationship in business is usually governed by a contract. Employees, independent contractors, vendors and suppliers, investors, clients and customers, licensors. The problem is that many use generic templates they barely understand or none at all. And that creates ambiguity, and ambiguity becomes leverage during disputes. For example, who owns IP created by a contractor? Is payment tied to milestones? Are there confidentiality? Can either side terminate freely? Are there non-compete or non-solicit clauses? These matter far more than people realize. A vague agreement might work when everyone is happy, but contracts are really tested when relationships break down. And that's the key here. You want contracts that are very airtight so that there are no disagreement between them. Moving on, Part 6, intellectual property and ownership. Many modern businesses are built almost entirely on intellectual property. That could mean software, branding, content, trade secrets, or proprietary systems. One of the biggest mistakes I see startups make is failing to secure ownership of IP. For example, a company hires a freelancer to build software. They pay the freelancer, but the contract never clearly assigns the intellectual property rights back to the company. And so now the company may not fully own it. That becomes a huge issue during investment or acquisition. Buyers and investors want clean ownership. If it's unclear, deals can collapse. That's why IP assignment agreements are so important early on. Part 7, raising money changes everything. Corporate law becomes even more important once a company starts raising capital. The moment outside investors enter the picture, the legal complexity increases significantly. Now you're dealing with securities laws, disclosure obligations, investor rights, dilution, governance rights, and fiduciary duties. A lot of founders think fundraising is just someone gives me money for equity. Legally, it's much more complicated than that. Even small fundraising can trigger securities laws issues. And many founders accidentally violate securities regulations because they don't realize offering ownership interest can qualify as offering securities. There are exemptions that must be followed, and improper fundraising can create regulatory risk. Investors also negotiate for protections like board seats, information rights, liquidation preferences, anti-dilution rights, and veto powers. So corporate law is not just paperwork during fundraising. It shapes who controls the company. Part 8, governance. Who actually has power within a company? Corporate governance refers to the system by which a company is directed and controlled. For a corporation, it involves a relationship among the shareholders, the board of directors, and the officers of the companies. Directors and officers owe fiduciary duties of care and loyalty to the company, meaning that they have to act in the company's best interest and avoid any self-dealing. In corporations, shareholders typically have the right to vote on major corporate decisions, approving mergers, amending company charter, and sharing the profits of the corporation through dividends. Next, you have the board of directors. The board of directors is the governing body of a corporation. They're elected by the shareholders and are responsible for overseeing the management of the company, setting strategic direction, and making major decisions. Directors do not typically manage the day-to-day operation of the business. That's the job of the officers. Officers are the executives who run the company on a daily basis, which include CEO, CFO, general counsel, etc., the C-suite. A lot of people think governance only matters for large public companies. However, governance issues often hit small companies hardest because the relationships are informal, documentation is weak, and authority structures are unclear. For example, can one founder bind the company's contracts? What approvals are required? What happens if owners disagree? Who controls finances? Who can issue equity? Without clear governance rules, disputes become personal very quickly. The operating agreement for the small business is especially important because it defines ownership rights, voting rights, authority, profit allocation, and transfer restrictions. Employment issues, Part 9. Hiring workers creates legal exposure quickly. Questions arise like, is someone properly classified as an employee or contractor? Are confidentiality agreements enforceable? Who owns employee-created work? One bad employment issue can create massive liability. This is why growing companies need systems and documentation, not just growth. Fast growth without legal infrastructure can become expensive later. Part 10, mergers, acquisitions, and eventually some businesses reach some type of exit event. Maybe the company is sold, merged, acquired, or dissolved. This is where years of corporate legal work become extremely important. Buyer's counsel legal due diligence includes reviewing all contracts, ownership records, litigation risks, employment matters, compliance, intellectual property, environmental. If records are messy, the valuation can drop dramatically. Sometimes deals fail entirely because companies fail to maintain clean legal documentation. A business with poor legal structure can look risky even if it's profitable. Corporate law helps make businesses transferable. That's one of its biggest purposes. Part 11. The best corporate legal work is preventative. It's about identifying risk early, structuring relationships properly, documenting expectations, and reducing uncertainty and maximizing benefits. Good legal infrastructure allows businesses to scale more safely. And interestingly, many major legal disasters start with very small decisions people ignored early on. Things like, we'll fix the paperwork later. We trust each other. We don't need a contract. We'll figure out equity later. Those small shortcuts become major decisions once money enters the picture. So my final thoughts, corporate law creates the legal foundation that allows businesses to operate, grow, raise money, protect assets, and survive disputes. It organizes ownership, it allocates risks, it defines authority, and it protects businesses from avoidable chaos. The strongest businesses are usually not just good at sales or marketing, they're structurally sound. And because when companies scale, legal weaknesses scale too. And often the businesses that survive long-term are not necessarily the ones with the best ideas. They're the ones with the strongest systems, including legal system. If you have any questions, please feel free to reach out.